Hello, folks. In this video, we're going to be talking about changing or possibly reversing the custody arrangement you have for your kids. Sometimes situations change, and the court orders that were entered a few years ago are just not practical anymore. Sometimes the kids just fail to adjust in that environment, or something changes about that environment that is just not reasonable for the kids to live in anymore. And if that is the case, and if you're considering a change in custody, then just keep watching. Before we get into the details, this is very important to understand. We can call it the golden rule of family courts. Family law judges are legally bound to act in the best interest of the kids. And this means that they will always place the interest of the kids above the interest of the parents. This is not something that they're doing out of altruism or niceness. This is something they're doing because that is what the law says. The judge's job is to uphold the law, which means the statutes and the case law that has already been documented. The judge's job is to uphold the law, and the law clearly states that the interests of the kids are above the interests of the parents. And the family law judges, on a day-to-day basis, when they come to their jobs, they know that this is the rule that they have to follow. You need to keep this rule in mind because if you're in a situation where you're going to present something to a judge, where you're going to try to decide if something is going to work in the court or not, you have to put yourself in the shoes of a neutral judge whose job it is to always put the interests of the kids above the interests of the parents. That is the rule that they follow as part of their job, as part of their training, and as part of the requirements as set forth by the law. This is very important, and if you keep this in the back of your mind, it will serve you well. If you're considering making a major modification to the current custody arrangement, then you need to understand these four qualification criteria. This is something that courts routinely look for before they decide whether a case even deserves to go to trial for a change in custody or any major modification. We will cover these four tests in the upcoming parts of the video, but let's quickly just look at them right now, one by one, before we go into details. The first is the current situation. Is a current situation bad for the kids? Are they in a situation where their well-being is being compromised? And is it harmful for them to continue to be in that situation? The second test, is the current situation substantially different from the one that was present when the current custody arrangement was issued by the court? It has to be substantially different from that time. The third test is the change in the situation that has worsened the environment. Has that change been documented in the court as something that was expected? Basically, was it an unanticipated change or an anticipated change? It needs to be unexpected or unanticipated. Otherwise, the change is not considered worthy of deserving a custody change. The fourth test is is a modification, the way you're proposing it, likely to improve the situation? So if the situation is bad and it's substantially different from before and the changes were unexpected, but your proposal is not going to improve anything, then there is really no point to change custody. So these four tests have to pass. And let's go forward and take each of these in detail with some examples. The first test is the current situation detrimental to the child's well-being? So are they in a situation that is harmful for their growth, for their emotional growth, their psychological growth? And is it really not a situation where kids can freely grow into healthy adults? Let's take a few examples. Are they being mistreated or abused? This could be that, the other parent is probably using physical abuse. Maybe they're punishing them too harshly, or maybe they're being neglected, they're not being taken care of, their food requirements, their health requirements are not being taken care of. Maybe they're not able to go to school, or maybe something is going on which you can categorize as mistreatment, abuse, or neglect. That's one example which shows that the current situation is bad for them. Are drugs being used in the other home? That's a big thing. Are the kids watching the other parent or somebody else in the other household do drugs in front of them? That is obviously very bad for them. You don't want your kids to be watching a drug addict take drugs in front of their eyes. If that is happening, then that is definitely a bad situation for the kids to be in. Are they falling behind at school? That's another example. Maybe the kids were, maybe they're just not able to cope with the studies. Maybe they're failing. Maybe they have really bad grades. Maybe they're falling behind at school. That is definitely a bad situation. Kids, there's no expectation that every kid will be outstanding, of course, but they should not be falling behind. They should not be failing in their grades. So if they're failing in their school, then it's a problem. Another another example is, are they ill but not getting the treatment they deserve? Have they developed a disease and the treatment is just not working? The environment just is just not conducive to a good treatment for whatever reason. If they're ill and they're not getting treatment, then of course that's a super bad situation for them to be in. Next test: is the current situation, which is agreeably bad, is the current situation substantially different from before? Is the current situation substantially different from the one that existed when the court orders were entered? The key word here is substantial. The courts always favor status quo for the children, which means that if the situation has gotten just a little bad, then the courts will likely not change the whole custody arrangement, because any kind of change is stressful and kids really need stability in their environment. So the situation today has to be substantially different from the situation that existed when the current custody arrangement was ordered by the court. There is no legal definition of substantial. It is quite broad, but if you talk to an experienced attorney, they will be able to look at the situation and tell you whether a court is likely to consider what change to be a substantial change. But the keyword here is substantial. An example: were they doing well at school before, but somehow they've started to fail their grades now? So if the kids were, doing fine, if they were outstanding kids when the current custody arrangement was entered, but now they're failing. So that's a substantial change, right? That's a pretty big change, and it's just not good for kids to be failing. Have they developed a new chronic illness which does not exist at the time the custody orders were entered before? If they've developed a new chronic illness, I'm not talking about little allergies here and there. Have they developed a substantial new chronic illness that was not there before? Then that's a substantial change that deserves something to change somewhere. Not doesn't say what exactly should change, but as far as this test is concerned, yes, it's a substantial change. Another example is, has the other parent recently taken the drugs? What if the other parent was sober at the time the custody orders were entered, but they have recently taken the drugs? They've become a drug addict, their situation has changed, they have become alcoholic, and therefore the situation has just worsened for the kids because now they see their other parent do drugs in front of them. Has the situation substantially changed? Yes, the situation has substantially changed because that was not the situation before, and this is really bad for the kids. Did the other parent marry an abusive person? Now, marrying is okay because people move on and get married, but have they married a person who's abusive to the kids? Now, that's a big change for the kids because now they're in an environment where this strange new person has come in and are abusing the kids. So it is a substantial change. Let's consider these first and second tests in light of the third test. The third test is of all the changes that have happened, of all the changes that have worsened the current environment for the kids, were the changes unexpected? Now, if the changes were expected at the time the court orders were entered, then they were already anticipated by the court, and the court chose to still order that arrangement, knowing that the situation is going to change. So the test here is, are the changes that have caused the situation to worsen unexpected, or were they unanticipated at the time the court entered the orders? Let's take an example. Kids graduating from middle to high school may be a big change. Yes, definitely. Uh, they probably had an onset of puberty, which is a substantial change for most kids, but it wasn't unexpected. Kids are expected to go through puberty. Kids are expected to graduate from elementary to middle or middle to high school, and even graduate from high school out into the world. But what is unexpected is that a child who was brilliant earlier is now unable to graduate. So graduating from middle to high school is definitely expected, and an argument cannot be made that situation has changed unexpectedly just because a kid graduated from middle to high school. But if a kid was brilliant earlier in middle school and now they've really fallen back in studies so badly that they're unable to graduate to high school, that is unexpected. Another example, developing an illness could be deemed as unexpected for the most part. If this illness is is not a little thing, it's not a temporary illness. If it's a chronic illness that kids at that age just don't develop, then it is definitely unexpected. It's definitely an unexpected change. Nobody was expecting that to happen. Remarrying is expected. Parents of kids, after divorce, they move on, they remarry, and it is also very common that the person that your ex has married brings their own kids with them, and your children get new step siblings. All that is expected. That's normal. That's what happens. That's just expected. Even if it's not written in the court order, that's just expected. But marrying a criminal or a person who's going to abuse your kids, that was not expected because it is not normal for the average person to go about marrying a criminal. It is just not normal. And therefore, that can be counted as something unexpected. It's an unexpected change. Nobody expected your ex to marry a criminal who's going to come home and abuse the kids. That is an unexpected change. The fourth test. Now, if you have determined that the current situation is bad, you have determined that it is substantially different from what it was when the court orders were first entered, and you have determined that none of those changes, or at least most of those changes, were just not expected or anticipated, the fourth test is, are the changes that you're proposing, the reversal in custody or the changes in the custody arrangements, are they likely to improve the child's situation? Because if they're not likely to improve the situation, then there's really no point in making the change, right? So, for example, just because a child got a physical health problem, developed a chronic illness. Yes, it is substantial for the child. Yes, it was unexpected, and yes, it is really bad. But how will changing custody make that illness go away? It is, the doctors are treating the child and the doctors are doing their job. And if they're unable to resolve the problem, then a change in custody is likely not going to help in that. Because, as a matter of fact, the change in custody might be even more stressful because any change causes instability and causes stress. And the court will likely say that if the child is undergoing treatment, let them stay in the current situation. Let's not make additional changes to the environment because making more changes will only cause there to be more stress. However, if you believe that the kids are not getting the treatment they deserve because the other parent is negligent or because the other parent is making extremely poor medical decisions, then an argument can be made that if the kids moved in with you, that you could get the situation to improve by engaging more with the treatment, and maybe you can demonstrate that you have maybe more qualifications or better ideas or the capability to be more closely engaged with the doctors, therefore it being likely for their health situations to improve. If the kids are doing poorly at school now and they were supposed to be really brilliant kids before, then maybe it is because the other parent is just not giving them the time of day. Maybe the kids have developed loneliness or depression, and that is causing them to do poorly at school. Maybe the situation at the other parent's household is just so hectic and chaotic that the kids are constantly distracted from their studies. It could be anything. If you believe that the situation in your house is more peaceful and you can engage more with the kids' education, get them back on track in school, then yes, then you pass this test, which means that a custody modification is likely to improve the child's situation. Maybe your job allows you more time to be with the child. Maybe the problem with the children or the problem with the current situation is that the other parent has a very demanding job and they're just not able to look after their kids. Maybe the kids are missing school, maybe the kids are missing their doctor's appointments, maybe the kids are just not able to engage with their friends because the other parent is just so busy in their job that they're unable to engage or give the kids any time. If your job allows you to engage more with the kids, then that is definitely a strong case to make that it is likely the situation will improve if custody were to change to you. And finally, if the current environment of the kids in the other parent's household is abusive and you have a much safer environment, crime-free, drug-free environment for the kids, then it's a no-brainer. It's like certainly the situation is likely to improve if the kids move in with you. Of course, it has to be substantial again. The situation has to be really bad in the other household, and the situation has to be really good in that context in your household for the court to consider giving you custody of the kids. And remember this, family courts favor status quo for the children to minimize instability. A petition to change a child's living situation needs to meet a high bar. It needs to prove that it is necessary for the children. And this is because children need a stable environment. So courts are not going to jump around or make the kids jump around from one custody arrangement to another custody arrangement and ask them to move their household, move their residences, move, the neighborhoods where they play with their kids, and maybe even move schools just because, there's a little bit of a benefit. No, family courts favor status quo for children. So if you can prove that there's a big benefit of the children moving in with you, then the family court may consider that. But if you cannot prove that, if all you can prove is just a little benefit, then it is quite likely that the family judge will say that let's not disrupt the kid's current situation. Even if it's a little bad where it is, let's not disrupt it because the disruption might cause more problems down the line than what currently exists. Let's recap the four tests. The first test is the current situation detrimental to their well-being? The second is the current situation substantially, the keyword is substantial, substantially different from before? The third test is, has the situation changed in an unexpected manner? That is, are the changes that have caused the current situation to worsen, were they never anticipated at the time the court orders were entered? And four, is the modification that you're proposing likely to improve the kid's situation? These are four tests. If you've determined that all these four tests are passing for the modification that you're considering, then it might be a good idea to take your case up to a lawyer. Just discuss it with an attorney who is experienced in these matters. And the attorney, there are two things at least that the attorney can do. One is validate your assumptions from a neutral perspective, because you might be biased, just like all parents of kids are. If you are biased, the attorney can give you an unbiased opinion. And the second thing an attorney can do, if you do decide to move forward with the case, the attorney can present the evidence in quite likely a much stronger way than you'll be able to present yourself. It's always a good idea. There is no necessity to go with a lawyer, but going with a lawyer, I would say, is really something you should consider doing, even if it's a short phone call. Just discussing with a lawyer is a good way to go about it. Thanks for viewing, and if you like this video, I hope you will click the like button. And if you want to see more videos, then I hope you'll click the subscribe button. Because you know what that does is that tells me that you liked it. It tells me that you found the video helpful and motivates me to make more. My goal is to enable you to understand how family law works so that you can make the best decisions for you and your kids. If you have any questions, leave comments. If you want to see a video about any other particular subject, just leave that in the comments. Thank you.